What would you do if you had to choose between taking care of a sick child and going to work? Let's take a look at the Family Medical Leave Act. In 1993, Congress passed the Family and Medical Leave Act, or FMLA, to provide job protection for employees in just such situations. The FMLA requires employers with 50 or more employees in a 75-mile radius to grant up to 12 weeks of unpaid leave to an employee who needs to take time away from work because of his or her own illness, to care for a sick member of his or her immediate family, such as a child, spouse, father, or mother, but not including his spouse's immediate family, and for the birth, adoption, or foster care of his or her own child. Employees must have worked for the employer for at least 12 months and for 1,250 hours during the 12 months preceding the beginning of the leave. In 2008, the FMLA was amended to allow for leave for family members of soldiers who are on or about to go on active duty. Also added was the provision for caregiver leave for wounded service members. This provision extends leave eligibility to a spouse, son, daughter, or next of kin for up to 26 weeks of unpaid leave. In 2015, the definition of spouse was amended to ensure eligible employees in legal same-sex marriages would be covered under the FMLA. The Act requires prior approval for leave to count as FMLA leave. Under the FMLA, the employer can permit or even require its employees to designate vacation or sick leave as part of FMLA leave so that they receive pay during at least a portion of the 12 weeks. In addition, the leave may be taken intermittently throughout a 12-month period. Except in cases of key employees, the law requires that the employer provide the same or an equivalent job for the employee when he or she returns from FMLA leave. Key employees are those whose absences could lead to substantial and grievous economic loss for the organization.